talk legal on Vital Point. Stay with us. We're going to take a musical break, and when we come back, Barrister Ishaku will be seated fully and we'll be talking legal. All right, stay with us. Don't touch that now. A whole lot of the Labour and the Obi camp were celebrating the fact that, yes, we have found a chink in the armor and the defense of INEC. But here we have it said the respondents opposed this. Could you bring us into knowledge of this? What does it mean? They oppose it, but it has been admitted as evidence.
Okay, thank you. You see, when you come to tendering evidence before the court, the fact that the respondents opposed or did not oppose the tendering of the evidence is not an issue. When you want to tender an evidence before the court, the party that brought the evidence will present it to the court. The party on the other side also has the opportunity to say whatever he has to say against the admission of the document.
Okay.
Now, it is the decision of the court to decide whether or not that evidence will be admitted based on the grounds of opposition, based on the grounds of objection raised by the party objecting the admission of the evidence.
All right.
And then another thing to know is that the admission of an evidence is not a conclusion of the case. An evidence can be admitted in court, but what weight will be attached to it in the evaluation of the case at the end of the day is what really matters.
When you say what weight will be attached to it, what does that mean?
Okay, if an evidence is tendered before the court,
yes,
witness statement, all sorts of evidence that will be tendered, at the end of the day, when the justices retire to write the judgment, they will evaluate the evidence. Now, in evaluating the evidence, they attach weight to it. That is the probative value they will give this evidence.
Okay.
Whether it will influence the judgment, whether it will tilt the decision of the court on the left or the right side.
Okay.
So admitting the evidence is not enough for any other person to start jubilating. Neither is rejecting the evidence also a ground for the other party to rejoice.
So their defense could still, in fact, throw out or dilute this evidence.
Absolutely.
So it's not hippie hooray yet.
No, it is not. It is not. It is now, at the end of the day, when the justices retire to write their judgment, they will now look at it. You see, admission of evidence is based on the relevancy. If the document you brought before the court at that time, the court considers is relevant, whether the other party raise objection, the court will still admit it based on relevancy. That's the position of the Evidence Act.
The Labour Party and Obi have been claiming that INEC have perpetually refused to provide documents for them. That has been an issue. Now, what do you think, before we go into that, what do you think of this evidence that has come? It's a serious allegation, I would want to put it that. Maybe you have a good word for it, against INEC and its transparency. Our credibility.
You see, election petition is a very detailed fact-based proceedings. One of the first stages of election petition is gathering the information. And unfortunately, most times the challenger does not have the vital information within his custody. That is why you see a lot of applications to INEC. The results, the templates, and everything. Now, if you made an application, the position of the law is that you apply for the evidence you are looking for. If you apply and INEC refuse to produce this to you, they will tender their application before the tribunal. We have made applications for this. If there is any cost attached to this, we have moved and we have taken a step further and paid for this. But yet, is in custody of INEC. And remember, INEC is a respondent in this petition.
Yes, it is.
So if you come with your application, you show the court that I have this application, I have applied for this, and INEC refused to give me. The court will infer that this evidence you are withholding is against you. So the court will have a decision, the court will have a mind on the evidence withheld by whoever is holding it.
Because we have two of the victims who are claiming that INEC, which is also a respondent, is withholding. The Atiku camp said the same thing after payment. The Peace camp said the same thing after the payment. What should the court be so to assuage these guys that they are, because Nigerians are are skeptical of the neutrality of the judiciary in this case, because the person that they want to nullify his election is already sitting as the president. So they believe that he will wield a measure of influence on the judiciary. Now, they have claimed that INEC has refused to bring into evidence the documents they have asked for. So what do we need them to do to assuage the feelings of Nigerians, especially who are interested in this case?
Well, you see, like I started explaining the procedure.
Yes.
When you apply for this, and then the party with whom the evidence is with refuse to release the document you are applying for, and in this case, INEC is a respondent in the case, they will bring it to the attention of the court. We have applied for this. This is the step we have taken, and INEC, whether I think that the second respondent in this case, refused to release the document. Now, it's only in rare occasions where the court will order you to produce the document. Well, if you produce or not, the court will have its opinion on this, and that will affect your case at the evaluation of all the evidence tendered before the court. Because why will you withhold an evidence if it is not against you? So this is usually the position. But to talk about the fear of Nigerians, one thing we know is the judiciary is the hope of the common man.
So they said.
So they said, and so it is.
He says.
Of course, if you come to me and you need help, where I will resort to for help to you is the court.
Definitely.
And as long as we keep saying there is no hope in the court, we will destroy the nation. This is an independent arm. We are looking at several election petitions, several cases. Well, for once, let us be objective. Let us look at it from a good perspective. These are judges. Present all you have to present to them, and let Nigerians wait and see what will happen.
How long will this go on?
Well, election petition is a procedure that has to do with time. Like the presidential election, maximum is 8 months.
And after that?
And after that, if you are dissatisfied, you apply to this, you appeal to the Supreme Court.
Now, what of it? Okay, you said so. If you are dissatisfied with it, you appeal.
To the Supreme Court.
And this takes more time.
Well, not really. The election petition is not like other cases. You see, the Supreme Court can give you adjournment of a case today to next year, maybe October. But it's not applicable in election petition tribunal. In election matters has specific time limit. From the time you appeal, you will be given date, you will be taken in, not like the other cases. Okay. So at most, immediately after this, you go to election petition, you appeal to the Supreme Court. Within the shortest time, the Supreme Court will give a decision.
Because ever since this country